invite our Honorable Mr. Justice D.R. Swaminathan for the lecture.
Good evening to one and all. When I saw my friends Srinivas Raghavan, Krishna Veni and Vijay Kumar, I felt unnerved. But seeing Justices Anand Venkatesh and Justice Vaidyanathan, I feel terrified. And but I'm picking up some courage. In fact, I wanted to address the audience in Tamil, but I was afraid Anandavalli may impeach me. Therefore, I decided to be rather formal while addressing you. I will take exactly 45 minutes or even less than that. I'm really happy that the hall is really full. I'm truly delighted to be one of the speakers in Cornelia Sorabji lecture series organized by Women Advocates Association of the Madurai bench of the Madras High Court. I feel all the more honored because the legendary educationist Shri N.R. Madhav Menon was one of the previous speakers. And of course, Justice Anand Venkatesh only inaugurated the entire series. I feel a little nostalgic too. Several years ago, I was in a bookshop in Nungambakam, Landmark. I saw a copy of the biography of Cornelia Sorabji. I had taken it. And then I saw the great actor, journalist and intellectual Cho standing in the same bookshop. I immediately passed on a copy of the book to my little daughter and asked her to get the autograph of the great man. My little daughter went up to Sri Cho and said in Tamil, "Mama, autograph konjam podrela." You know, Cho is known for his wit and repartee. He said, "Cho is only one letter word. Adu eppadi innu konjamakuradhu?" That was his instant response. So saying, he put his autograph, and this Cornelia Sorabji's biography with Cho's autograph is one of my most treasured possessions. Cornelia Sorabji is a contested historical figure. She had the courage and guts to oppose the politics of Mahatma Gandhi. When Catherine Mayo published her book Mother India, the entire country condemned it as a drain inspector's report. But Cornelia Sorabji wrote a favorable review. She remained pro-British till the end. In fact, she settled in England and died there. But then we can't be judging her retrospectively. She deserves to be an icon for all of us, particularly the women lawyers here. She cleared her LLB in 1897. Then she passed her Vakil's examination. But then enrollment was denied to her. She fought her way through, and with sheer grit and determination, she was able to get enrolled as a lawyer. She then became a barrister. She set up a practice in Calcutta and had really a good practice. She is rightly recognized as India's pioneer woman lawyer. I wholeheartedly commend this association, particularly Ms. Anandavalli, for instituting this memorial lecture, thereby perpetuating her memory. When Ms. Anandavalli invited me to deliver a talk, I chose this topic primarily for two reasons. The first one is rather sentimental. I got enrolled in 1991 and I set up my independent practice in 1996. Initially, all that I got was only what we'll call as prohibition bails. Justice Shivappa was the portfolio judge, and all that one needs to do was to stand up and say how many letters and whether there was any previous case or not. That's all. See, if you take today's cause list, the bail petitions are categorized offense-wise, murder case like that, one by one. In those days in the cause list, the petitions were not grouped. And I used to file at least 2 petitions a day. I was filing only after liquor bails, nothing else. But one leading lawyer who was practicing on the writ side, who never stepped into the criminal court, seeing my list in the cause list daily in the criminal court, thought I was a pulley in criminal law. But only I knew that I was filing only prohibition bails and nothing else. So one day when he called me, he said, Swaminathan, I see you are having a good roaring criminal practice. I just pretended as if I was having a great practice. And he was probably fooled by my pretension and began to refer me truly big briefs. And I got, as many as 4, in the very first month, 4 IAS officers' briefs also. Therefore, I owe my initial breakthrough only to my practice on this side. So that is one reason why I chose this topic for my lecture. The second reason is of recent vintage. Last year also, I was holding the very same portfolio. A petition for anticipatory bail was listed before me. It had earlier suffered a dismissal at the hands of Justice S.S. Sundar. Even though serious allegations of forgery and cheating were made, it was primarily a case of monetary liability. I therefore thought we can try to balance the equities. The liability was somewhere around 2.5 crores. Friends, what did I say now? No, what did I say? I want to know whether they are listening. What did I say now? A petition anticipatory bail was listed before me. It had earlier been dismissed by Justice S.S. Sundar. I thought to balance the equities, I told the petitioner's counsel, if you are willing to clear a portion of your liability, I am prepared to give you anticipatory bail. The petitioner's counsel said yes. He paid a sum of rupees 40 lakhs as DD. For another 45 lakhs, he also came forward to give collateral security. This represented almost 50% of the total liability. I thought substantial justice has been served and I granted him anticipatory bail. The case was going on for almost 3, 4 or 5 hearings. And 1 year later, my order was set aside by the Hon'ble Supreme Court. The Supreme Court said, mere clearing of a portion of liability will not constitute a change in circumstance. I really got a real rap on my knuckles. Something more was stated. The Supreme Court said, the judge who dismissed the first anticipatory bail petition is very much available in Madurai bench. When he is there, how this judge could have taken up the second anticipatory bail petition? Therefore, quoting a 1987 Supreme Court, my young friends, please note down. 1987 to SEC 684. That is the leading case on subject. Shahzad Hassan versus Ishtiaq Hassan Khan. You just note citation alone. 1987 to SEC, page 684. The Supreme Court said what the judge did was wrong and it set aside my order. Even the words judicial discipline, etc. were also employed. See, if my order had been reversed on merits, it's absolutely okay. Nothing wrong. I am doing my job, the higher court is doing its job. It can be DB or Supreme Court, no issue. But getting, reversed on this ground, that really made me think. That was another reason why I chose this. I really wondered if the counsel who had appeared before me, the petitioner or the intervener, had they told me, Judge, you could not have heard, you cannot hear this matter. So please recuse yourself, let it be posted before the other judge. I would have gladly done it. Of course, I am a little hesitant to use the word recuse. in view of what is now going on in the Supreme Court. யாருக்கும் புரியலையா? யாருக்கும் புரியலையா? புரியுதா புரியலையா? புரியலையா? வேணாம், மைக் ஆஃப் பண்ணிட்டு தான் பேசணும் அப்படின்னா. ஓகே, முடிச்சப்புறமா பேசுறேன், என்ன சொல்றேன். ஆல் ரைட். Now coming to the topic of the day. What do you mean by bail? Black's Law Dictionary defines bail as obtaining the release of oneself or another by providing security. See, this constitutes a very, very important element in our entire criminal justice system because it concerns the personal liberty of the individual. All of us know our constitution places personal liberty at a very high pedestal. The Supreme Court in very many decisions has emphasized the importance of following due process in the matter of effecting arrest. Friends, I would request each and every one of you to go through one very recent decision of the Supreme Court. 2018 10 SEC page 443. 2018 10 SEC 443. Social Action Forum for Manavadikar versus Union of India. See, if you read this judgment, you will understand the entire jurisprudence regarding arrest. See, in this case, the earlier decisions like Arnesh Kumar, Joginder Kumar, all those decisions, the direction given therein have been authoritatively affirmed. The Supreme Court says the power to arrest is one thing, the existence of the power to arrest is one thing, the justification for the exercise is another. All those points you will find in abundance in this 2018 judgment, and I request you to go through that. See, even though number of procedural safeguards have been laid down regarding arrest, the fact remains crimes are committed every day and police have to necessarily arrest the offenders. You know, we will categorize the bail, we'll offense into two categories, bailable and non-bailable. All right. A person is arrested for a bailable offense. Can he be released straight away? No. If you read section 436, you will see only if the man is arrested is prepared to give bail, that's the word they use. If he is prepared to give bail, only then he can be released, let out on bail, not otherwise. See, India is a country where crores of people are living below the poverty line. They may not be in a position to even give bail. What do you do with them? See, now the law says, if he is indigent, release him on own bond. And if within 1 week from the date of his arrest, if he is still not able to furnish security, court will presume that he is indigent and grant him bail. So these are the changes that have now come. And in fact, all these changes in the statute have come about on account of the intervention of the Honorable Supreme Court, particularly in the late 70s and the early 80s. At least 3 judges' names you should recollect now. Justice Krishna Iyer, Justice P.N. Bhagavati, and Justice Chinnapareddy and others. And those days, the under trials used to remain in prison for a term longer than what they would have actually been, given, even if they had pleaded guilty. That was the scandalous state of affairs. Now that situation has substantially improved. And it was therefore something of a consolation to me when I came across an article by one author by name Lo Siu Ling. Ziping Barnala Nasalala, independent by Lo Siu Ling. He deals with one Singapore case of one EO. That EO was prosecuted for harboring somebody who had overstayed even after the expiry of his visa. He was sentenced to 7 months. He files an appeal. In the appeal, he was acquitted. But problem was, even though he was granted bail, he was not able to raise that security of $20,000. Therefore, he had to remain in prison. And he had spent the entire 7 months by the time he was acquitted from the case. The Chief Justice of the Singapore court said, this is a regrettable state of affairs and that courts must ensure that this does not occur again. Why I said I felt a little consoled when I read this. You know, if electricity goes off in our house, what we will do is to see if the neighbor's house also, there also the electricity is gone. If that is also dark, we will feel happy. Is it not? That's a human psychology, and I am no exception. Therefore, when I read that in Singapore also, the same situation of under trial suspending the entire imprisonment term, I felt a little consoled. But why I am referring to that now is, during the last 1.5 months, I came across quite a few cases in which the subordinate courts have been requiring the accused to deposit, to make cash deposit. In quite a few cases, I would say almost some 10 to 15 cases I saw. See, of course, the relevant provision is section 445. That is the relevant provision. It says the court can permit the person to deposit a sum of money in lieu of executing bond with or without sureties. But then, this is a concession meant to be availed by the accused, of course at the discretion of the court. It is not something which the court can demand from the accused. So the leading case on the subject is N. Sasikala versus Enforcement Officer, 1997, 1 CTC, page 317. 1997, 1 CTC, page 317. Sasikala was granted bail on condition that she must pay 3 crores. She filed a petition before Justice Shivappa, and Shivappa set aside the condition saying the amount is too high and onerous. Probably Justice Shivappa did not know 3 crores is nothing for Sasikala. Probably was not aware of it. See, Justice Shivappa in his judgment had referred to quite a few earlier cases. One of them is this Husainara cartoons case. You must read that, Husainara cartoon. 1980, 1 SEC, page 81. 1980, 1 SEC, page 81. See, in that judgment, the Supreme Court said the bond amount should not be fixed based on the nature of the charge. Supreme Court says you must take into account the individual financial position of the accused and then fix it. It must be an individualized decision. And once you have decided to release him on personal bond, you must not order an inquiry into his solvency. All those principles have been laid down in Husainara cartoons case. See, in fact, in section 440 of CRPC, it has been laid down that bail amount should be fixed having regard to the circumstance of the case and that it shall not be excessive. Now I'll tell you something interesting. This is a statutory mandate under section 440 of CRPC. It may but it is a constitutional mandate in USA. Amendment 8 of the US Constitution says excessive bail shall not be required. See, imagine, even they see the issue is so important that they chose to embody it in the Constitution itself. Amendment number 8 of the US Constitution. And 442 of CRPC says High Court or the Sessions Court can reduce the bail amount if it sees that the police or the magistrate have stipulated it rather on at a high level. Friends, the law regarding bails and anticipatory bails is all about balancing. See, on the one hand, you have the presumption of innocence, the right to liberty, etc. On the other, you have this public interest. So it is the court that has to somehow reconcile the two. And now, what we have to see is if there are any definite guidelines governing the discretion of the court. I came across an article by Vrinda Bandari. It is published in the NUJS Law Review. She characterizes the bail jurisprudence evolved by the Hon'ble Supreme Court as inconsistent and unclear. That is the label which this author has given to the bail jurisprudence evolved by the Supreme Court. She takes only 2 cases for analysis. She takes this Papu Yadav case, the notorious politician and rowdy. 2007, 1 SEC, page 70. Then she takes the other one, 2G case, Sanjay Chandra versus CBI, 2012, 1 SEC, page 40. One is 2007, 1 SEC, page 70. The other is 2012, 1 SEC, page 40. If you remember 2G case, you will be able to remember. And when I say 2G, if you remember something else also, I cannot help it. See, in Pappu Yadav's case, the accused had been in prison for more than 7 years. The trial also had been substantially over. Still, taking note of the serious allegations against him, the court said, if the argument founded on presumption of innocence is to be accepted, then logically, bail must be granted in every case. So saying, it rejected his bail petition. On the contrary, in Sanjay Chandra case, the 2G case, the Supreme Court recognized that the right of personal liberty is the most basic of all fundamental rights. It says, right to bail is not to be denied merely because the sentiment of the community is against the accused. But Sanjay Chandra case has been recently distinguished in 2017, 5 SEC, page 406, Virupakshappa Gowda case. 2017, 5 SEC, 406. Friends, if you see these three cases, Pappu case, Pappu Yadav, Sanjay Chandra, and Virupakshappa Gowda, if you take these three cases and go through the principles that have been laid down therein, you will find that the comment made by Vrinda Bandari is quite justified. See, in fact, in Virupakshappa case, after referring to, because the counsel for the accused was heavily relying on Sanjay Chandra case, after referring to Sanjay Chandra case in paragraph 14, the Hon'ble Supreme Court says, passages from Sanjay Chandra have their relevance, but the same cannot be made applicable in each and every case for grant of bail, and that the factual matrix was quite different. Since this is more an academic session, I thought it would not be improper on my part if I bring up a recent decision of the Honorable Supreme Court for discussion. All of us know that the most high profile case that is now going on is P. Chidambaram. He has been implicated in a case of money laundering by the Enforcement Directorate. He applied for anticipatory bail before the Delhi High Court. It was dismissed. He then moved to the Supreme Court. A two-judges bench comprising Justices R. Bhanumati and A.S. Bopanna justices, in the decision reported in 2019 SEC Online SC 1143, 2019 SEC Online SC 1143, while denying him relief of anticipatory bail, went to the extent of observing that anticipatory bail cannot be granted in economic offenses. Friends, I repeat, the ratio is that anticipatory bail cannot be granted in economic offenses. The court went on to observe that the power under section 438 of CRPC, being an extraordinary remedy, has to be exercised sparingly. Economic offenses stand as a different class as they affect the economic fabric of the society. They place reliance on the decision reported in 1998 2 SEC page 105. 1998 2 SEC page 105. Directorate of Enforcement versus Ashok Kumar Jain, for the proposition that in economic offenses the accused is not entitled to anticipatory bail. Friends, this is a judgment by two judges bench. I, in all humility, request you to go through the judgment in Ashok Kumar Jain, 1998 2 SEC page 105, and you can see for yourself if any such proposition has actually been laid down. You can see for yourself. On the other hand, the leading case on the subject is, every member of the bar knows, the leading case subject is another. Anticipatory bail is the leading case. சொல்லுங்க, சத்தமா சொல்லுங்க யாராவது. Sibia, கால் விடணும். The leading case subject is Gurbaksh Singh Sibia versus State of Punjab. 1980, 2 SCC, page 565. 1980, 2 SCC, page 565. See, this Gurbaksh Singh Sibia is by a 5 judges bench. 5 judges bench. In fact, that case before Supreme Court arose out of a judgment of the full bench of the Punjab and Haryana High Court. The Punjab and Haryana High Court laid down a set of propositions to guide the discretion available under section 438 of CRPC. Now, my friends, please listen to me very carefully. The 7th proposition laid down by the Punjab and Haryana full bench was, in serious cases like economic offences involving blatant corruption, anticipatory bail should not be granted. That was judgment of the Punjab and Haryana full bench. The Supreme Court in Gurbaksh Singh Sibia rejected this proposition. It held in clear terms that there is a risk in foreclosing categories of cases in which anticipatory bail may be allowed because life throws up unforeseen possibilities and offers new challenges, and that the courts must always have wide discretion to decide. The Supreme Court also held it is not correct to state that this power should be exercised only in exceptional cases. I just want you to compare these two. See, some judges even say in murder cases, don't grant AB. When Mrs. Rajini appeared before me last week, it was a 302 case, I gave her AB in a murder case. See, therefore, see, it all depends on the factual matrix of each and every case. We cannot be saying, don't give this, you cannot give that. We cannot foreclose categories. In fact, that's the expression, foreclosing categories is not my expression. It is a judgment, it is from the Supreme Court in Gurbaksh Singh Sibia's case. So, my young friends, all of you must go through the Sibia case line by line. All right. Now, one academic issue. All of us know section 438 has undergone an amendment. All of us know that. See, earlier it was only a single line. High Court of Session, if it thinks fit, it can grant, that's all. Nothing else was there. Now, a set of parameters have been laid down in section 438. The amendment came in the year 2009. So now, all that I want to know is whether the propositions enunciated by Gurbaksh Singh Sibia before amendment, do they still hold good post amendment also? This is an academic issue on which I want you to reflect on. Personally, I would think Gurbaksh Singh Sibia is still holding good. But tomorrow, if one of you file a anticipatory bail for a person accused of an economic offense, I will have to necessarily follow? Supreme Court, what is this? Sibia is the Supreme Court, international court. I should follow only Chidambaram only, P. Chidambaram only. Only that judgment I'll have to follow. Because there is something called judicial discipline, and I have already been given a lesson in judicial discipline, and I would not like to forget it so soon. All right. Now, under what circumstances courts will be justified in granting anticipatory bail? One judgment you will have to necessarily read is 2016, 1 SEC, page 152. 2016, 1 SEC, page 152. Badresh Bipin Bhai Sheikh, State of Gujarat. It is by a 2 judges bench, very eminent bench, comprising Justice Sikri and Justice Rohinton Nariman. Please read. I don't want to take my time now, take your time in going through it. Please read for yourself. It's really, it will be profitable to read the entire judgment, 2016. Likewise, when it comes to the case of a grant of bail, what are the broad principles? 2012, 9 SEC, page 446. Ash Muhammad versus Shivraj Singh. You just read these two judgments, and I can assure you, you will have a complete grasp of both section 438 as well as section 439. Just read for yourself. Friends, a number of issues arise for consideration in this branch of law. I'll just run through and highlight some of them. The first issue is whether anticipatory bail should be for a limited period or it should be for the till the end of the case. And there are two divergent views. CBA says there should not be any time limit. CBA has been followed in a number of subsequent judgments, but two judges bench have not chosen to follow that, and they are saying no, it is only for a limited period. High Court can grant AB till the accused is receives summons from the court concerned. Only till then he has to go to the regular court and take a regular bail. That is what several other decisions have been given, and now the case has been referred for an authoritative pronouncement by a larger bench. The reference has been made in Susila Agarwal versus State of Delhi, 2018, 7 SEC 731. 2018, 7 SEC, page 731. If you read the Susila Agarwal, I can assure you, you will have a complete understanding of this issue regarding this limited duration or unlimited. The second issue will be whether a child in conflict with law, a juvenile, whether he can apply for anticipatory bail. See, again, the judges of the Madras High Court took a different stand. Justice P.N. Prakash J, he initially felt a juvenile can apply for anticipatory bail. Then subsequently he changed his view, and in Ajit Kumar's case he said, no, he can't apply, it is not maintainable. And the division bench in Vignesh case, 2017, One Law Weekly Criminal, 878. 2017, One Law Weekly Criminal, 878. It upheld PNPJ's second opinion in Ajit Kumar's case and said, no, it will not lie. But a contra view has been taken by the Kerala High Court. Justice Vaidyanathan also has said not maintainable. But the Kerala High Court has taken a contra view in bail appeal number 3320/2018. I think you can get it in Indian Canon. 3320 of 2018. There the division bench Vignesh case has also been referred to, but a contra view has been taken. I personally find the Kerala judgment to be more appealing. See, the division bench of the Madras High Court, in my view, has taken a very narrow and technical approach. It said a child can't be arrested. Only a person who can be arrested, he can apply for anticipatory bail. I agree, child can't be arrested, but he can be apprehended. He can be put in that home. He can be denied bail also in certain cases. Therefore, what's the big deal about the name? Why should we quibble about the name? Apprehension or arrest? Therefore, personally, I find the Kerala judgment to be more appropriate. But then, if tomorrow you file a petition for anticipatory bail before me, what I will do? I will follow only Vignesh, judicial discipline. Huh? All right. Okay. When arrest takes place during the pendency of an anticipatory bail petition, should it be dismissed as infructuous or it can be converted into a bail petition? Justice C.T. Selvam in one case said it will not become infructuous, it can be considered as a bail petition. And last week I had one interesting experience. A case was registered only under section 174 of CRPC. I gave anticipatory bail but put the petitioner on stiff terms. The next day the council made a mention, please include some offences also which may later get incorporated. I said, what is this, man? Our Madras High Court in the year 2010 in Divan's case held the anticipatory bail is for the case, it is not for the offence. And quite a few counsel in the bar also nodded heavily in agreement. If one of them stood up and said it is only for the case, not for the offence. But afternoon, my dear friend Robinson produced the Pradeep Ram's case, 2019 AIR SC 3193, very important judgment. 2019 AIR SC 3193, Pradeep Ram. And now the Supreme Court says if a new section gets added later, there is no need to cancel the earlier bail. He can be court can straight away direct the police to commit him to custody. Now that is the judgment. So all of you must read Pradeep Ram as it is one of the recent changes in the law. And our Madras said Divan's judgment has been overruled. And this one thing, of course, in section 437 of CRPC, a number of limitations have been incorporated while dealing with a bail petition in the case of a non-bailable offence, the most serious cases. But then those limitations set out in section 437 cannot be applied in 438 or 439. Fine. But then when we are dealing with the special offences, I would classify offences into three categories: less serious offences, and special offences. When we are dealing with special offences like NDPS or Unlawful Prevention of Activities Act, when those cases are coming up, the power of the High Court cannot be exercised because those limitations. NDPS Act, all of us know, section 37. What section 37 says? Section 37 says, court can grant bail only if it is satisfied, in the case of commercial quantity, only if it is satisfied that the accused is not guilty of the offence and that he is not likely to repeat the offence. These twin tests must be satisfied. Only then bail can be granted. That is a limitation standard set out in section 37. Unless that standard is satisfied, court cannot grant bail. I cannot say I am having 439 power, I will grant. I cannot say that. And this has been categorically laid down in Satpal Singh versus State of Punjab. Satpal Singh, State of Punjab, 2018, 13 SEC 813. 2018, 13 SEC 813. But here, I had a very interesting experience. Last year, during vacation sitting, before one judge, as many as 22 bail petitions involving commercial quantity were filed, but they were not put under the NDPS category. They were put under some other, I think, 506 category. And by a one-line order, all of them were granted bail. All of them, 22. But we judges, I do not know about the experience of my revered, esteemed brothers. We get a number of Matakardas. We used to get. And I used to read all of them because, it's a real, stress buster. And probably one rival advocate who really lost out in the game, he had sent to me, see, I filed a bail petition before you. You said that section 37 not satisfied. You dismissed my bail petition. But see, the same guy filed another advocate and got. And he gave the entire list. When I verified from the registry, I found to me horror that by one line order, 22 NDPS bail petitions, commercial quantity granted. I can assure you, honestly, the learned honorable judge was absolutely unaware of it. There was a collusion between the petitioner's accused counsel and the government counsel. It's a reality. Then what? I got so angry and I asked the government counsel to file cancellation petitions. Petitions were filed. I cancelled all the 22 orders, saying the very grant of bail is illegal because section 37 has not been satisfied, Satpal Singh has not been met, and I cancelled. And one of them filed an appeal before Supreme Court, and the Supreme Court set aside my order. Supreme Court said, yeah, you are a judge, that person is a judge. You can't set an appeal over that person's order. Therefore, you have committed illegality. And said my order was set aside, and the earlier order was restored. When I said reality, this is also included. See, we now have, a hierarchy of courts. Magistrate Court, CJM, Assistant Sessions, High Court, Supreme Court. It goes on like that. பேர் அப்புறம் சொல்றேன் உங்களுக்கு நான். பேர் அப்புறம் சொல்றேன். We have a hierarchy of judges. And see, once you move the High Court, thereafter you cannot move the subordinate court. And on this issue, according to me, this is rather a well-settled position. Karnataka High Court Justice Ramajoyce, sitting in a division bench, has authoritatively laid down. And in Madras High Court also, have seen a number of cases that after you move the High Court, if you suffer a dismissal, whether on merits or as not pressed, thereafter you cannot move the Sessions Court or the Magistrates Court. Therefore, when in one case after suffering a dismissal before the High Court, the guy moves and gets an order before the Sessions Court, a cancellation petition was filed before me and I promptly set it aside. The same afternoon, my friend Robinson produced a judgment of the Honorable Supreme Court in Sharath versus State of Maharashtra, saying nowhere the Supreme Court has laid down that after dismissal of the bail petition has withdrawn, he cannot move the Sessions Court. He said, and when the Bombay High Court set aside the order, Supreme Court said, non-application of mind on the part of the Bombay High Court. Okay, that is another judgment. I will not now tell you as to how I overcame that. All right. Next question. In 2005, 4 SEC page 303, Adri Dharan Das, State of West Bengal. 2005, 4 SEC 303. Supreme Court says you cannot grant interim order in a pending anticipatory bail petition. That is a law laid down by Supreme Court. But day in and day out, I am granting, say, when PPA asks for adjournment, call on so-and-so, till then, restrain from arresting the petitioner. I am passing an order. But Supreme Court says you can't grant any interim order restraining arrest. But then, if you read section 438, there is a provision for granting interim anticipatory bail also. Therefore, I feel when the law permits me to grant an interim anticipatory bail, why not I pass this kind of an interim order? That is what I feel. And whether the complainant can intervene in pending AB or bail, that's the question. I request all of you to read the leading judgment of Justice M.M. Sundaresh, reported in 2010, 4 CTC, page 833. 2010, 4 CTC, page 833. Satyavani Ponrani versus Samuel Raj. A very interesting judgment. And all of you know that in SCST Act, there is no scope for granting anticipatory bail because there is a statutory bar. Supreme Court last year said in 2018, 6 SCC 454 said it is possible to grant AB in certain cases, but then in a review that has been overturned and law has also been amended. Therefore, that is only an academic point. See, in some states, there is no provision for AB at all, no 438 at all. In those states, the aggrieved individual can file writ petitions and get this relief under Article 226. The decision on the point is Hema Mishra case, 2014, 4 SCC 453. 2014, 4 SCC 453. And all of us must note the distinction between cancellation of bail petition and a challenge to the order granting bail. See, that's a very subtle distinction, and I would want you to read 2 judgments where this distinction has been beautifully brought out. 2008, 13 SEC, page 584, Narendra K. Amin case. 2008, 13 SEC, 584. And from Indian Kanun or Supreme Court website, you can get Justice Bhanumati's judgment, again a brilliant judgment. Bharatibai, Bhimabai, Barvat. I leave all the citations with your president. See, we just ran through some of the leading cases, and if you read with some depth and attention, you will really find that the label given by Vrinda Bandari, that the law that has been evolved so far is unclear and inconsistent, that label is quite justified. And ultimately, you can't have any straitjacket formula in these cases. Every case will turn on its own facts. And I would say it will equally depend on the individual judge, his subjective personality, that will have its own play and force. I would say there is something called water tap model of justice. There are actually 4 taps. If you open one tap, water will flow in good measure, it will keep on flowing. The other one, if you open, sometimes in stutters it will come, sometimes it will come, sometimes it will not come. If you open the 3rd water tap, only air will come. In the 4th water tap, only blood will come. How many water taps? 4. Yeah, which judge is represent which water tap, you can decide for yourself. And at this juncture, I would request each and every one of you to read Benjamin N. Cardoso's The Nature of Judicial Process. It's a brilliant book, The Nature of Judicial Process by Benjamin N. Cardoso. He's a legendary US judge. If you go through his book, you will know the reality of adjudication. And I'll take 5 more minutes. And regarding drafting of petitions, I have one request to the younger members of the bar. See, you must make a full and frank disclosure. if your earlier bail petition has been dismissed, you say, this is my second bail petition. I earlier filed one, it was dismissed. This is a change in circumstance. You justify. If you are going to bank on the government counsel, thinking that even if I suppress, he will not let me down, on the day that government counsel may be absent and Robinson may be standing there and he may spill the beans, you will be in trouble thereafter. So therefore, you must frankly say everything. And first para, date of arrest, if it is a bail petition, the offences involved. In the second para, you state in a nutshell the entire prosecution case. In the next para, your broad defense. And then you have the standard format. And when you type out, take some more care so that there are no mistakes. And one important aspect that I wanted to stress here is, it is not possible to be a mere practitioner on the bail side. You must have a substantial grip over the substantive law also. You must have good grip. See, if you are going to argue a section, if in an NTPS bail petition involving commercial quantity, unless you are aware of the latest case laws, you will not be able to succeed. Therefore, do not for a moment to think it's enough. I'm just filing a bail petition. I get or I don't get. If I don't get, I again file one more petition after 2 weeks. That should not be your approach. In fact, in the year 1996, when I was practicing almost exclusively on the bail side, one very senior lawyer who was my well-wisher told me a story from Mahakavi Bharadiyar. In one poem, the story is found. Some of you might have heard about this. There was a rishi. The rishi came under a curse. The curse was, he will die the next day and he will become a pig in the next birth. That was a curse. Once a curse has come, you can't really avoid it. You can't avoid the consequence. See, those days, rishis can have families also. So the rishi called his son and gave him a sharp sword and told him, I'll be born as a pig soon. I'll be somewhere in the vicinity only. You come and slaughter me, kill me. That is the only way I can get liberation. Because I cannot avoid this curse. And as expected, the next day the rishi died and he was born as a pig. And the son with the sword goes. Then the rishi pig said, son, just now I have born. I'm just enjoying the love of my mother. Therefore, you come later. The son returned. He came after some time. By then, the pig had become a boy pig. He said, just now I'm learning many things from my father. Therefore, come later. He came later, after 6 months or so. The rishi pig said, I am now dating a girl pig. Therefore, I am having fun. Therefore, come later. See, after the courting was over. See, the word court, you see. Court means this is court. And court has another meaning. Dating is also, that's also called courting only. Court has got 2 meanings. So after the courting was over, he got married to that girl pig and he raised a family also. When the son came, he said, no son, don't ever come again. You keep the sword yourself. Don't ever come again. I'm happy now. So Bharadiyar narrates this and said, and makes some very sharp comments also. That was the condition of India at that time. See, this story may look like a joke, but it contains a very profound wisdom. See, that senior lawyer felt that I was a bright young boy and I should not get confined in the bail portfolio, bail practice alone. See, bail practice is very easy. You make very easy money. Almost daily I used to get 1,000 rupees per bail petition. Very easy to make money. But if you, Krishna, when he knows for a second appeal, they will not pay more than 5,000 rupees and they'll have to keep the bundle for 20 years, 5 years at least. Therefore, in civil, there's more work, less pay, less money. But in bail practice, there is a good money, almost no work. So therefore, and you should not like this rishi pig, we should not get confined here. So that is a warning that was given to me by that senior lawyer, and I even now feel indebted to him. And therefore, I did not confine there. I branched out into the other areas also. See, in fact, when Ms. Anandavari told me that I should do something about this, I give a talk on the subject, I really didn't have time. So what I did was, yesterday I requested the bar members who come to my 12th court. I said, each one of you should give me some points. And I'm happy to note, in fact, I just in the notice board I said, in fact, I spoke about John Abraham, crowdsourcing, crowdfunding. Have you heard of John Abraham? Yeah. See, John Abraham is a legendary film personality from Kerala. See, in fact, he had taken a movie in Tamil also, Agraharathil Kadai. Some of you may think everybody in Agraharam is a Kadai. That's another matter. No, I'm not on that. Agraharathil Kadai. There is a donkey in Agraharam, and this film is about it. And John Abraham later took a movie by taking recourse to crowdfunding. There be every people become, they become a producer. So invoking that John Abraham, I requested each idea from each one of the bar. So today, nothing that I said is original. Every thought I gave came from the bar only. I am only representing to the bar. Before I conclude, I want to say only two things. I was talking to one top bureaucrat last week, truly a top guy. They are setting up cyber police stations all over Tamil Nadu. In-house recruitment is going on. And they have to give their willingness. And those who are giving their willingness, they will be subjected to a skill test also. The result was quite surprising. The sub-inspectors fared far better than the inspectors. Constables fared better than the sub-inspectors. See, the reason is cyber, the technology. The youngsters are in the constabulary. Many of them are BE computer science graduates. They are able to do well. But inspectors are not able to. So this officer was telling me that investigation will be done by the SIs and constables, and the inspector will only be putting his sign in the final report. No problem. But when he is cross-examined, he will simply collapse in the witness box. He was saying there is a digital divide in the society. Digital divide in the society. The youngsters are on the right side of the digital divide. Now, so long, you take politics. When Tony Blair became the Prime Minister, at a very young age. Obama, very young age. And the French President, Macron, he was 39 when he became the president. But don't ask me his wife's age. She was 25 years elder. She was 66. Huh? His teacher, 27. But point is, now this digital divide, the youngsters have an upper hand. They are having e-library, e-filing, e-courts, everything. Therefore, the notion that law is an old man's profession, maybe maybe it's an idea that is outdated. The future belongs to the youngsters. With this note, I thank all of you.